Ladies and gentlemen, it is a pleasure to be here, and I would like to thank the organizers for this possibility. Well, unlike Professor Savic, I am the PowerPoint guy, so you have my presentation available and you have a chance to look at my presentation. I am not forced to look at me all this time. Well, and the problem I would like to talk today concerns the topic of my article. And in my article, I dealt with the principle of primacy, which is a principle of EU law which is 60 years old now. It has been formulated by the case law of the Court of Justice in a way which still raises questions today, since these cases always respond to some particular sub-issue, and that they therefore do not deal with this principle of application of EU law in a comprehensive way. And at the same time, these decisions, for obvious reasons, do not address issues that are important for member states of the European Union. They do not reflect the national perspective and the position of national constitutional courts. So today's contribution is based on this article, so I would like to draw attention to some of my conclusions. I would like to first identify the implications of primacy principle on for legislative bodies, for administrative bodies, and for courts. The reason for this approach is that the competences of these authorities differ. However, the principle of primacy is usually in textbooks and in scientific articles described in a uniform and universal way, without the authors concerned distinguishing between the effects on various national authorities. And the second aim of my contribution will be to answer the question of the impact of the primacy principle on national courts, especially national constitutional courts. The question is, do they have the power rule differently from the Court of Justice and from the EU law? Well, member states of the European Union in general are in a similar position as a sub-state of a federation. According to the Court of Justice, the EU law takes precedence over national law, which is solution typical for federal states. A certain peculiarity is that the European Union, certain peculiarity of the European Union is the fact that this principle of primacy or supremacy, to be more general, is enshrined only in the case law of the Court of Justice, and therefore has no support in the EU constitution. In federations, on the other hand, the constitutional enshrinement of the principle of supremacy is something quite usual. It's a basic thing. And another difference is that the judicial structure of the European Union hasn't been federalized. And as a result, the law, which should function in unity, should be in practice dealt by two different judicial systems. Well, this was something which was addressed by Professor Radovic. She expressed certain concerns. I'm not that critical. To me, this is actually something that brings a sort of a dynamics into the functioning of the European Union law. We have this chance for a judicial dialogues between the Court of Justice and national constitutional courts, and the history shows us that this judicial dialogue was very fruitful for the development of European Union and its law. The case law of the Court of Justice on the primacy principle is quite well known, so I'm not going to deal with it. You have a short summary of these cases on my slide. To put it in a simple way, to summarize it, it is a principle according to which the EU law has an absolute primacy over national law, even the national constitutions. Another thing I would like to point out is that the survey of the case law of the Court of Justice shows that this principle is well established and has been clear for many years. But I would like to also draw attention to another thing, which is, I would say, also something quite typical for cases of the Court of Justice, and that's that they should not be taken too literally. In legislation, every word matters. Whereas in judgments of the Court of Justice, you can sometimes find things which simply are not true, which do not make sense. I have highlighted them by red color on this slide. As I said, I don't want to analyze these relatively old decisions, although they are still considered to be the law. They haven't changed. But my point was to highlight the fact that the principle of primacy has somehow evolved throughout the years, and also the fact that judgments of the Court of Justice sometimes have to be taken with a grain of salt. Finally, there is no reason, I believe, no point criticizing the Court of Justice for the way it has conceived the principle of primacy. EU law as supranational law cannot function effectively without having unconditional primacy over national law. But there must be certain limits, both legal and political, which was addressed by Professor Savic. Said things for member states in the Central and East Europe is that unlike founding member states of the European Union, we have acceded to the European Union knowing that the EU law should, according to the Court of Justice, work in this way. So we can hardly oppose these old decisions of how the EU law should work and how it should interact with national law, since we have accepted them via our accession to the European Union. So what does the principle of primacy mean in practice? Well, the answer at first glance is uncomplicated. National authorities may not apply national law that conflicts with the EU law. And this is how it is usually simply put in textbooks. And I'm focusing on it in my article. One of the problems we have in Europe, for example, in comparison with United States, is that we haven't developed the theory of preemption yet to limit somehow the effects of of EU law on national laws. And when it comes to principle of primacy, another thing is important. The principle of primacy has different effects on legislative bodies and on those authorities which actually just apply the law, courts and administrative authorities. And the reason is that a situation may happen when the principle of primacy requires certain activity on the side of legislative body to amend, to repeal, or to adopt a new legislation, national legislation, whereas at the same time, because of the principle of primacy, no obligation arises on an authority which is to apply the law, on a court or administrative authority. And that's because of the fact that the principle of supremacy and primacy is strongly linked with the principle of direct effect of EU law, which is of no concern for legislative bodies, but have to be taken into account by courts and by administrative authorities. And this is, for example, where Czech courts tend to err, since it seems to me that in many cases they simply over-apply the EU law, giving it a direct effect where it shouldn't have the direct effect, arguing that that's the result of the primacy, but that's simply not the true. I have lost myself. I don't know on which slide I am, but I think that I will skip the Mangold case, since this was something I was going to tell you to give you an example, but I guess that I don't have enough time to deal with this issue, and you can read it in the article. The second case in which the principle of primacy does not apply is the situation where the application of the EU law would exceed the competencies of national courts, national authorities. I will explain it. The problem in generally does not arise in case of ordinary courts, since according to the EU law, they are in a position that they have to apply both the national and the EU law as well, the simple law. It's a result of, it's an application of the Simmental decision of the Court of Justice. And from the perspective of domestic law, the EU law in generally a simple simple law is. Well, on the other hand, when it comes to constitutional courts, the situation is different. They are not here, at least not in the Czech Republic, to apply the simple law. They are here to guard the constitutional principles. And from this perspective, the EU law may not be the part of the reference network of the law they have to enforce. In my article, I have discussed the possibilities for the Constitutional Court to take a position on EU law, provided, of course, that the Constitution allows it. And you can see here an overview on my article. I have identified 5 possible approaches, at least how they could work within the Czech legal system. Well, the Czech Constitutional Court has adopted the 4th option. It does use the EU law, but only as a sort of a reference framework. So basically, it primarily applies the national constitutions, national constitution, but while interpreting it, it takes heavily into account what the EU law says. From my perspective, the 5th option is the safest option for constitutional court, trying to pretend that it simply does not exist and leave the bad work for lower courts. But that's my personal opinion. The absence of a provision providing for the primacy of EU law in primary law in founding treaties of the European Union gives the national laws and national constitutional courts the possibility to identify their own approach according to their own rules for the application all within the jurisdiction. And this is the consequence of the fact that although the EU law should act federally in the European Union, the judicial systems of member states is not functioning as a federal-like system. The reserved or rather conditional attitude of the German, Italian, and other constitutional courts towards the principle of primacy is well known. It is therefore astonishing that this complicated system, which was created solely in the case law of the Court of Justice, has lasted for almost 50 years without giving rise to an open judicial conflict. And as we all know, the situation has changed in 2012. It was the Czech Constitutional Court which was the first to rebel. And since 2012, a number of constitutional courts have more or less directly denied or challenged the primacy principle. And this has created a conflict between the EU and national law, and it makes sense to look at the reasons why this conflict may happen. And it may happen for either material or formal reasons, as, for example, the standard of human rights protection might not be sufficient at the EU level, or the EU law may threaten the national identity, the constitutional identity. The third option is that the EU may act ultra vires. And the 4th option is that the very same situation may be qualified as a matter of EU law by the Court of Justice and as a matter of constitutional law by constitutional courts. And this is what happened in Poland, since the reform of judiciary can be perceived as a problem from the perspective of EU rule of law on one side, and it can be also addressed as an issue falling within the procedural autonomy and a free space which the state has in order to organize its own system of justice. And the difference between these two groups lies in the fact that for the first group, we do not reject the application of EU law a priori, but only ex post because of a certain insufficiency. And in the second case, we refuse to apply the EU law without any further consideration because we consider the relevant situation to be a matter governed exclusively by a national law. Well, at first glance, it may seem that these two approaches are incompatible and therefore cannot exist side by side. The existence is wrong, but I do not share this approach. And indeed, I believe that these approaches are mutually compatible. And the existence of national constitutional courts make sense since, we could have it. Here are for solutions, how to bring together the problem with incompatibility of national law and EU law, and I could add a fifth. It is recorded, so I'm sort of afraid to say it, but a fifth revolutionary option will be to completely erase national constitutional courts, to abolish them, and then most of the problem disappears, but that's something we don't want, I guess. Please erase it, yes. We have now in the Czech Republic, personal changes at the constitutional courts, and they are picking from history of people, the things they said and are using it against them. So that's, I don't want to happen to be in a similar situation 15 or 20 years later. Well, what I'm trying to say here is that the European Court of Justice interprets the EU law, and that's why it was able to interpret the principle of primacy. And it is not, therefore, concerned with national limits. It cannot deal with them, since it is not empowered to interpret and apply the national law. Whereas national constitutional courts, on the other hand, they interpret their own constitutions. This is their main task. And it is up to member states and all the institutions to ensure that the whole system within the state is coherent. And it seems to me that, in general, executive power and legislative power seem not to have any problem with EU law, within the limits and with limits which were formulated by the Court of Justice. If they did, they would take a certain action, but we haven't seen any. All these amending treaties were adopted without any strong, appeal against how the things works at the moment, how they work currently. In the Czech Republic, 20 years, we are now members of the European Union for almost 20 years, but we haven't amended the constitution. We have a provision how to become a member of the European Union, but we have no provision on how to deal with our membership internally from our perspective on a constitutional level, and we have also no provision how to leave the European Union. And although I don't want this to happen, I think that those things have to be addressed by national laws, and here is the place later for the constitutional courts to deal with them and to interpret them. So from my perspective, the work of constitutional courts must be perceived as follows. They do not review and reassess the case law of the Court of Justice in the area which is concerned by the principle of primacy, but rather interpret their own constitutions and ascertain the conditions and limits of membership within an international organization. And that's something they should do. That's their main task. So the rejection of the conclusions of the Court of Justice is not a denial of the primacy of law. It's, I would say, more a task for other institutions of that particular state to address the problem and to solve it. Unfortunately, if we look at these options which we have here, the third one, the political one, is the one which is the easiest, as was demonstrated by Great Britain. And that's probably not what we want. Well, the last thing I would like to focus on before my time expires concern the national identity and its relation to principle of primacy. Since so far we have worked with cases involving the parallel work between the Court of Justice and EU law on one side and national constitutional laws and constitutional courts on the other side. Nevertheless, national courts and the Court of Justice, as well as the EU law and national law, they do meet in certain cases, and they work together. It concerns definitions of the content of certain legal concepts. One of them is the national identity. It's also the rule of law, and it used to be also the case of fundamental rights. And it is the national identity on the basis of which national specifics can be taken into the account, and thus the full primacy of EU law cannot be asserted. National identity is a term of the European Union law, and the content of this term should be determined by both the EU and through the Court of Justice, and also by the national law through national, mostly constitutional courts. So we speak or we refer to EU law as to autonomous legal system with autonomous terms and the autonomous interpretation, but this is not the case of the term of national identity. So this term is not absolutely independent of the national law. The national law shines through this term and contributes to its meaning. For example, material core of our constitution, the respect for certain fundamental rights. That's something that should, evolve on the level of a state, but transfer into the EU concept of national identity. Unfortunately, that's a theory. In practice, it simply doesn't work. And we have seen it already in history. I can demonstrate it, for example, on a case of fundamental rights. I don't know if you are familiar with a quite old case, Liselota Hauer. That was a case which concerned the protection of fundamental rights of a German citizen in Germany, and her fundamental rights were threatened by the EU law, by EU regulation. Well, the case ended at the Court of Justice through the reference for preliminary ruling, and the Court of Justice rejected the argument that since the EEC back then does not regulate fundamental rights, that the situation must be solved based on German standard of human rights protection, said that the EU itself should protect it, so created an autonomous concept of EU fundamental rights, and then in order to define it, made a huge leap in a circle and ended back at the level of national constitutions, saying, since we don't have this common definition, we have to draw from constitutional legal orders of member states, but gave these rights a new meaning, new definition, which was rather separate. So it was rather a rhetorical thing which the court made, but gave the concept a new EU meaning. Well, and I think that this is an excellent, a very smart adaptive strategy, how to deal with problematic issues where the EU law overlaps with national law. And I'm afraid that the constitutional identity might be in a similar position, that it might be gradually replaced by the EU concept of national identity, which only rhetorically draws from national concepts. It remembers me lessons from history classes at my school and high school. We were told that, the Catholic Church cleverly gave new content to original pagan feasts, and later did communists the very same thing to Catholic feasts and branded them into communist feasts. So they were able to build on what was existing, but give it a new meaning. And I'm saying it without any irony or criticism. I'm Catholic myself, but this is what happened. And it seems to me that the European Union is quite often doing the same thing with certain concepts, as, for example, was the case of the fundamental rights, the rule of law, and now with the national identity. So yes, from a theoretical perspective, a national identity may be a barrier to the EU law, a block of a principle of primacy, but in practice, I don't believe that it's going to work. I believe that the Court of Justice will find a way how to give this term new, special EU meaning. Well, that's it. Thank you.